The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of 3 cases. One of them will be without oral argument. That case is State of Iowa versus Antoine Williams. That case is submitted at this time without oral argument. Our first case for oral argument this afternoon is Mandy Tripp versus Scott Emergency Communications Center. I believe Mr. Bribriesco is going to go first. First of all, I want to do a real quick sound check. Justice Oxley, can you hear us?
I can.
Thank you. And if you would do a quick sound check, Mr. Bribriesco, before you go into your argument.
Sound check. Good.
Thank you. Good afternoon, Counsel.
Thank you, Your Honor. May it please the court, counsel. My name is Andrew Bribriesco, and along with Gabriela Navarro, we represent the claimant, Mandy Tripp. There are 3 issues before this court. The first is whether the agency misinterpreted the Brown standard when it considered the occupation and training of Ms. Tripp. In other words, whether the agency misinterpreted the Brown standard as a subjective test rather than an objective test. The second issue is whether the court should clarify or modify the Brown standard as it relates to the diagnosis of post-traumatic stress disorder. The third issue is whether the agency's decision is supported by substantial evidence. Ms. Tripp has been a 911 dispatcher for over 17 years. She's good at her job. She has PTSD. She treats for PTSD. All of her medical providers have linked her PTSD to a readily identifiable event, the dead infant phone call that occurred in September of 2018. Despite all of the medical evidence, including a medical expert, the agency concluded that Ms. Tripp did not meet the Brown standard. The commissioner interpreted the Brown standard to include one's occupation. And we submit the Brown decision does not support that interpretation. The language in Brown and the policy of Brown do not support that interpretation. Brown came after Dunleavy. Brown carved out an exception saying, well, the policy concerns in Dunleavy don't exist when we can trace a mental injury to a readily identifiable event. There's a sufficient badge of reliability and legal causation will have been met.
I don't read that case that way. And I don't see a subjective test anywhere in either Brown or Dunleavy. What I see is this notion that if it's an unexpected cause or unusual strain in comparison to the normal strain or stress of that job, then you can recover for a mental injury. The only thing Brown added is it doesn't have to be a stress on other employees. So I don't know that I just read it as still an objective test. Am I missing something?
No, we would agree that it's an objective test, and that objective test is something for the medical experts to determine and weigh. The DSM-5 provides objective criteria for the diagnosis of post-traumatic stress disorder.
Legal causation. I mean, Brown does say it has to be an unexpected cause or unusual strain, correct? So how do you determine if something is unexpected or unusual unless you compare it to the job?
Going back, the DSM-5 provides an analysis for post-traumatic stress disorder, which has the objective criteria as what is traumatic to
Measure whether the event is unexpected in the course of the job or whether the event is unusual. That's a medical diagnosis.
agree that the language in Brown contemplates for that medical diagnosis. In reading Brown, that Mr. Brown had PTSD. All of the cases before the agency dealt with PTSD.
The Brown, I mean, it's unusual for a store clerk to be robbed at gunpoint. For a 911 operator, it kind of comes with the territory that you're going to get these stressful, traumatic calls that may involve the death of an infant, right?
Shouldn't be a legal barrier for if a first responder can factually prove that they have the mental diagnosis of PTSD. Although
Requires then that we reconsider Brown and Dunleavy, which you've asked for, but they are a settled law. I mean, what we've said is medical causation, which what you're talking about is not enough. There's this additional concept of legal causation for mental injuries. You want us to change that law, which I suppose we could, but isn't that what you want us to do?
I think that there would be more guidance for the agency to determine these types of cases if Brown was modified. We believe Dunleavy is good and wise. We're not attacking Dunleavy and the policies of Dunleavy, which establish that if a worker proves medical causation first, and then second, whether they can prove legal causation for accumulative stress. With Brown, which took language from a Montana statute, not even applicable to mental injury specifically, it didn't provide, as we know now, that language doesn't provide enough guidance, especially when it comes to first responders. As you can see from the agency's decisions that have decided since Brown, there's a lot of inconsistency. We have a DOT officer who has trained at the police academy, who has seen manhunts that end in dead bodies, but this particular charred event is what reaches the level of legal causation. Well, so how is the agency going to decide what level of generality are we going to view these events?
Isn't the real question here whether under Brown we're going to look at the event or nature of what happened compared to other people in that role or other workers generally? Do I have that right? And I think what you're arguing is we don't look at that particular role, we look at other workers, we look at the workforce sort of more generally. Do I have that right?
That's correct, Your Honor. We would say that using the objective standard, it would be based upon a reasonable person and the reasonable person's sensibilities. And the commissioner kind of talks about that when he discusses the Shookman case in his decision. He says, coming upon a charred body, that would shock anybody with regular, normal sensibilities.
Something. But well, you just said any reasonable person, but we have to look at the context. Is it reasonable for people to be on a phone call like that, unless you're a 911 operator?
On a reasonable person standard, taking a phone call that is 4 times the length of a normal 911 call involving the death of an infant while a mother is screaming guttural and awful, not being able to provide the help that she's been trained to do, including after the phone call ended, believing that maybe this 6-month-old infant was killed by a claw hammer. That isn't
The 911 call part of the administrative record?
Yes, it is, Your Honor. So the 911 phone call plus the events afterward, any reasonable person who is hearing this live, it raises to the level of being traumatic. It meets the objective criteria by the DSM-5 that she is witnessing the death of another.
Secretary in a law firm, and I got a phone call, and that's what was on the other end. I think you're right. I mean, that would be really, really wild and out there. But if I was sitting at the comm center with my headset on, watching cops come and go all day, hearing sirens going, and received training and have been doing it, how can that be, for lack of a better term, not expected?
Well, I think that's where there's going to be some issue with how this standard is applied by the agency. In all of the cases before the agency, there was always witnesses by the defendants testifying as to what is expected and not expected. whether it's mentioned how suicide attempts are expected for a correctional officer, but it was the nature of that suicide attempt. Receiving emergency phone calls is what she does daily, distraught callers daily. But receiving a phone call involving the death of a 6-month-old infant, a call where there's gruesome and vivid details afterwards, that's something that beyond a seasoned 911 dispatcher is expected to take.
If there's a PTSD diagnosis, and it can be assigned to a particular event during the course of that person's work, is that going to be then automatic coverage for workers' comp?
Well,
Really to be decided at that point?
so there has to be a determination made by the agency for medical causation. And there can always be a dispute as to medical causation. Defendants are always able to get medical experts to challenge the diagnosis and causation. But yes, we would submit that they're based upon Brown and the policy set forth in Brown. If you can trace back a mental injury to a singular event, there's a sufficient badge of reliability where legal causation will have been met. Or we're stuck in a situation where you're going to have first responders falling in between the cracks, being able to say, well, they have PTSD from a work event, but aren't able to recover benefits, the only remedy that they're allowed to have.
It seems to me you're eliminating the legal cause requirement. I mean, you're basically saying if a medical physician gets up and says, hey, look, I've examined the patient and so forth, to a reasonable degree of medical certainty, there is PTSD, and to a reasonable degree of medical certainty, it was caused, as a matter of fact, by a workplace event. For you, that's enough, I think. Am I mischaracterizing your position? No additional overlay of kind of, quote, legal cause. You're saying that cause in fact established by a medical professional is good enough to have a workers' compensation claim. And I'm not trying to mischaracterize, I'm trying to understand. Yeah.
And I believe that satisfies the policy concerns of why the court adopted legal causation to begin with in Dunleavy.
Limited to PTSD only, or is it if a claimant suffers other mental health conditions as a result of a singular event, would those be covered as well?
The claim that we're bringing forward is purely for PTSD, as that diagnosis itself has the objective criteria as to the nature of the traumatic event, the extent of disability for that event, and how one is experienced.
The situation happened where a similar phone call was received and the manifestations were with OCD. All of a sudden, somebody is really fastidious about hearing the phones ring and they have to answer the phone, they have to check, make sure. Where do we draw the line? You're saying PTSD. There could be very similar facts that result in a different diagnosis.
Well, I'm not here to discuss any other diagnosis because the case before us deals with PTSD, and I believe that diagnosis.
You're asking for a carve-out of a pretty well-established point of law, and you're asking for a singular carve-out, and what about all the others? Are we going to have then a waterfall of everyone else saying, what about mine?
Avalanche, as this criteria of PTSD is you can draw the line with PTSD. I believe part of the diagnosis of PTSD that's important is that many people suffer from PTSD, especially first responders that go untreated.
And OCD, I'm thinking of lots of different diagnoses I've seen in similar type situations.
And Your Honor, I believe that the objective criteria for PTSD is why I think the carve-out would make sense. Other jurisdictions other than Iowa have carved out for PTSD. Other jurisdictions, such as Illinois, we briefed the Diaz case, utilize a similar language, actually, to the mental standard we have in Brown. They use an objective standard as well, because they found under the case before them that a first responder may never be able to recover because really every life and death situation is expected. And an unusual strain, how are we supposed to judge what an unusual strain is? I believe PTSD would qualify for an unusual strain.
Counsel, you had started, you started to go back to kind of the reason we have legal causation. And doesn't that stem back to the statute itself that says that benefits are provided for personal injury sustained by an employee arising out of and in the course of the employment? Is that what we're trying to get to with legal causation, the arising out of and in the course? And how would you draw that line? I'm sympathetic to the idea that it seems like, workers' compensation is intended to benefit employees who face particular harms in their particular industry. I think we even said that in Delaney. We quoted from Graves, the Wyoming Supreme Court, in saying, it would be unfair to the employer who pays premiums on the assumption that they cover only injuries caused by their industry. So I'm sympathetic to your concern about PTSD with first responders, but how do we draw that line so that it doesn't become kind of like the stress that was at issue in Dunleavy?
Well, I think that when Dunleavy announced the legal causation standard, it was the waterfall. They were concerned that every single stress dealing with the workplace could potentially qualify, anxiety, OCD, or any of those types of diagnosis. What we're saying is medical causation for PTSD to a work event, it would be almost treated like any other type of injury. Pre-existing conditions. When you start considering the occupation of a worker, you're essentially punishing first responders for signing up to do the job that they're expected to do. And I believe I've run out of time, and
And it's my understanding Chandler Surrency, pronounced it right?
Correct, thank you. May it please the court, counsel. My name is Chandler Surrency, and I, along with Jane Lorenzen, represent the Appellees in this matter, Scott Emergency Communications Center, and Iowa Municipalities Workers' Compensation Association. Mandy Tripp has been employed as a 911 dispatcher since 2002. Answering emergency calls is her primary job responsibility. On September 30th of 2018, Ms. Tripp took a call from a mother whose baby had died. Ms. Tripp remained on the phone with her for approximately 2 minutes. In this case, the deputy, the commissioner, and the district court have all found that Ms. Tripp is not entitled to workers' compensation benefits under Iowa law, specifically pursuant to the standard described in Brown versus Quick Trip, as this court is well aware. It is our position that all 3 of those prior decisions were correct under the law as prescribed in Brown, and further that Ms. Tripp has failed to present an argument to warrant overturning Brown. I would like to first look at whether Ms. Tripp has presented a compelling argument to overturn Brown. This court has held that it doesn't overturn precedents lightly and will not do so absent a showing the prior. Yes.
Before we get there, opposing counsel makes an argument that his argument fits under Brown, and that really it's up to us to sort out whether Brown deals with a particular field or employees generally. What's your argument on that point?
Our argument is that under Brown, it should be a subjective test based on the specific job in which the claimant is employed. Now,
Objective doesn't make sense to me. I mean, I know you say it in your briefs, but it doesn't make sense. I mean, both Brown and Dunleavy talk about sort of the event needs to be sudden, traumatic, and unexpected. That's objective, isn't it?
so I think, and I'm very glad you're asking this question, because I think there's some confusion in terms of the definition of subjective versus objective. I think in some instances we've looked at objective as just like a reasonable person, anybody in the world, versus subjective being determinative or determined based on the specific employment. The Graves case, actually, which is the Wyoming case that was mentioned in both Dunleavy and in Brown, goes into a discussion about objective and whether that refers to people within that specific employer, people employed in that area but not with the specific employer, or workers as a whole. And so I can agree that there's confusion with the subjective versus objective. And so when we're using subjective, we're saying it's determined based on the specific employment, not objectively every worker.
So that's my view is it's two different, we're arguing about two different objective standards. And I just view Brown as an evidentiary decision. We held in Brown, you don't need to present in that particular case where it was a gunpoint robbery in a convenience store or whatever, that other workers in convenience stores don't experience that event. It's obvious that it's sufficiently sudden, traumatic, and unexpected. So I view that as simply an evidentiary issue, not a subjective-objective distinction. So given that, where does this case stand?
With this case, I think that there are sort of three issues with this case, and it's whether Brown should be overturned, what the standard is under Brown, and then if we're looking under Brown as it stands, whether Ms. Tripp met the standard. So this case, I think, with the way that you are framing it, I think if we're looking at if an objective standard can take into account people within that specific field, so, in Brown, we're looking at a clerk, a convenience store clerk. Here we're looking at a 911 dispatcher. I think if we're using the word objective to look at the specific employment, I think we can agree that it would be an objective standard. Subjective was just used as in not the entirety of the population.
Why is it limited in that way? Why wouldn't we look broader? In other words, is there some assumption of risk issue here that, when you enter one of these fields, that you've given up some workers' comp right if you get PTSD, or you have to have a certain thickness of skin? Why is it limited?
Characterize it as an assumption of risk, but I think that we have to look at the particular employment, because what is normal for me on a certain day is going to be different for what's normal for somebody else in a different field on a certain day. And so I'm not saying that it's an assumption of risk by any means, but to determine what is out of the ordinary, I think, has to be based on what an ordinary day looks like for somebody in that particular position.
Counsel? So if you're a 911 operator, how do we decide what is out of the ordinary? Because every call is going to be different.
Absolutely, I think that that's right. And I think that touches on an interesting issue that we're dealing with in this case, which is the medical causation and the legal causation. And so we've briefed this issue fully, but there is a question in this case with regard to medical causation, specifically whether a phone call is even sufficient to rise to the level of a PTSD diagnosis based on the DSM-5 criteria. So I think that's sort of step one in terms of analyzing a 911 dispatcher. But that goes to the medical causation. Is that what you said, though? So you take the position that from a medical standpoint, a phone call itself might not even rise to the level of PTSD. Is that something that we can say as a matter of law, or don't we need to rely on the experts? Absolutely, I agree. We need to rely on the experts. So looking at your question as it relates to legal causation rather than medical causation, I just want to note that we're not stipulating to medical causation in a 911 dispatcher issue. I do think that there are certain circumstances where a call, if we're assuming a call is sufficient for a PTSD diagnosis, would be compensable under the Brown standard. For example, something that happens less frequently than a call where a person has passed away. For example, say like a hostage situation. If somebody called 911 dispatcher, they had to stay on the phone, be involved with a hostage situation, negotiations, things like that.
Assuming we're not overruling Brown and Dunleavy, we agree with their own decisions, is it then the determination of whether the event is sufficiently unusual? Is that a substantial evidence issue that the commissioner makes, or is that for us to decide?
And that it's a substantial evidence issue. It's an issue of fact, whether or not they met the standard under Brown, that this was sufficiently unexpected. So it's our position that would be a substantial evidence issue. And essentially would be within.
Was the claimant diagnosed with PTSD?
Interesting thing that you bring up, Your Honor. The claimant was diagnosed with PTSD 16 days, I believe, after this phone call. Now, under the DSM-5, a PTSD diagnosis can't actually be made until at least a month after the traumatic event. And so her first actual diagnosis was by a social worker 16 days after the event.
Perhaps the objective criteria of the DSM-5 maybe doesn't serve a sufficient screening function in the way the claimant contends, given that, at least as I read the DSM-5, she couldn't have been diagnosed with PTSD at the time she was.
You're absolutely right there. I think that what the claimant is asking for is essentially for a medical provider to be able to make both a medical causation determination and a legal causation determination simply by making the PTSD diagnosis.
I saw that in the record that she was diagnosed within 16 days, and I know that that's sooner than the DSM allows. But wasn't that affirmed later beyond the period of DSM time that she did legitimately get tagged with that diagnosis?
Was then later diagnosed by a PhD, and then also she underwent an IME in which she was diagnosed with PTSD.
A death case, that a 911 operator gets a death case when opposing counsel talks, he calls it the dead baby case. So there's quite a difference in how we're even approaching it. But can you tell me, it's along the lines of what's been asked, but I still am a little troubled. So then has a 911 operator pretty much written off, is it in their contract when they sign into a job? Have they pretty much written off that no matter what happens and it messes with your head, you're not going to be able to go to workers' comp? How do they ever do that?
Your Honor, I don't believe that that's the case. As I said, I think there are certain circumstances where an injury, a mental injury, as a 911 dispatcher could be compensable. Now, again, I'm assuming that the question relates to someone who takes a call, not, a person physically walks in to.
And extend them to a point where you would concede, yeah, that'd be workers' comp material.
For example, like I mentioned previously, if a 911 operator took a call for a hostage situation.
These facts with a baby, can you see this ever getting to that level? Because that does seem kind of difficult.
Under these specific facts, I don't see a level where this would be a compensable injury. I can change the facts to
Worker, how about the worker has only worked there a couple weeks?
I still don't know that that would be considered unusual or unexpected in this specific line of work. And again, this
A cumulative effect, after the, so many dead baby calls, it's the final straw and you're over the edge.
if we're looking at more of like a cumulative injury, I think we're under Dunleavy at that point. In my mind, Dunleavy is more of like the cumulative mental versus Brown is a sort of a singular instance. And so then under the Dunleavy standard, you would have to compare it to what other employees are experiencing on a day-to-day basis.
Many people seem to treat injuries to infants as a different category. You hear occasional slang about bad baby cases in the plaintiffs and defense bar, suggesting it's a category of case that's kind of different from other cases. So that's the question of generality that's been referred to. I think an argument at least can be made that an infant death case is different from, my house is on fire, come help me. Why don't you explore that with me, please?
I think, first of all, we sort of get into an issue of the slippery slope, like where do we draw the line between an infant versus a toddler versus a child, things like that. Also, I think that
Someplace. I mean, you're suggesting that there's no immunity for 911. You're saying that under some circumstances there might be PTSD. So we're going to draw the line for sure. Arguably, one could categorically draw a line and say, well, an infant death is different, is sufficiently different from what you ordinarily get. I mean, arguably one could do it, and so I'm inviting you again to come back at that.
I think what we need to focus on here is, under the law, this has to be unusual or unexpected. And Ms. Tripp testified, as did 3 of her coworkers, that, calls about infants are not.
Conclusion. I mean, I did see that they concluded, well, it's not unexpected. It happens 0.0000123% of the time. And correct me if I'm wrong, as I know you will, and I would appreciate, but the evidence seemed to be that, yes, infant death calls happen occasionally. And there was some statistics that indicated it was really relatively rare. The people served 20 years and got 2 or 3 in the course of 20 years. Why isn't, we should focus not on their conclusion, well, this happens with some frequency. I mean, the fact is, in a 20-year career, it might happen a couple times. Isn't that sufficient to put it in a different category than fire, police, accident kind of situation?
It is on that alone, only because, obviously this case was dealing with an infant who had passed away. Nobody asked Ms. Tripp or other workers, how many times they had dealt with a child that had passed away. And I think that there would probably be similar numbers for lots of different categories, such that.
I mean, could we say there are some categories of events that are obviously part of the regular stress of the job, and even we as a court can see immediately that's not a basis for a comp claim under this sort of artificial legal causation standard we have. There are some that are, like in Brown, sufficiently obviously unusual that they can be. And then there's a group in between where we rely on the commissioner as the finder of fact to make the decision. And can we say that maybe this is in the middle category? I mean, that might be one approach. I don't know.
Absolutely fair to say that this is a fact question that should be in the hands of the commissioner to decide. Is that what you were getting at? I apologize.
I think so. Thanks.
And Counsel, if we do that, then what kind of standard do we give to the commissioner in making that determination?
I think it's, honestly, as with most anything else that goes to the commissioner, the commissioner will have to hear all of the evidence, including evidence from other similarly situated employees, to determine whether that is something that rises to a specific level. And with that, I am out of time. Appellees respect. Oh, I'm sorry.
Chief, do you mind if I just follow up with that?
Of course not. Go ahead.
And that was my question, I guess, is what is that standard then that we would be asking the commissioner to apply when they look at the facts? Because ultimately, aren't we trying to determine under the statute whether or not the injury arises out of and in the course of the employment? That's really what's at issue, isn't it?
In terms of a legal causation in work comp, absolutely, the arising out of and in the course of. I think the standard that we would give the commissioner is simply what Brown already states. What is, if something is atypical within that specific employment. With that, I am out of time unless there are any additional questions. Thank you so much, Your Honors.
Thank you. The agency is very accustomed to weighing medical evidence and weighing the credibility of witnesses. They're very accustomed to doing that for the majority of the cases they see. They're also very accustomed to using the AMA guides. So putting the Brown language, and we're just asking for a little bit more clarification to the Brown language. Using an objective standard is something that the agency can do. It provides the guidance necessary for really everybody.
Somebody hires on as a hospice care worker, and on the first day of employment, the employee sees a death, finds that traumatic, and then is subsequently diagnosed with PTSD. Under your view of Brown, is that a compensable injury at that point?
Yes, it would be, as long as the agency found medical causation and no other no other personal events in their life, as long as the
Packing plant, let's say, and they go on the first day and they're shocked, kind of appalled. They didn't really understand what went into processing animals. They quit, subsequently diagnosed with PTSD. I assume your answer is the same. That's a compensable injury.
Under those scenarios, I don't believe the death of animals accounts under the objective criteria of DSM. I think the bigger point is, just like in a physical injury, if somebody walks on the job and gets injured on the very first day, just to Justice Oxley's point, it falls under the category of injury, regardless if they started 5 minutes before.
Okay, but let me give you another example. You probably remember I wrote this decision about the idiopathic fall a few years ago, and there was a worker in a fast food restaurant, and he suffered a seizure and fell. And I said, in my opinion, because I thought it was logical, well, if he suffered his injuries because it was on this hard tile floor of the fast food restaurant where he was working, if that is what caused him to suffer the severe injury of the fall, he's entitled to comp benefits. And I tell you, the legislature couldn't get in session fast enough to overrule my decision. So, I mean, there is sort of an artificiality to the mental standard, but it's well-established law, isn't it?
I just believe there needs to be a little bit more guidance for the agency, because who's going to determine what's traumatic? Who's going to determine what is unusual? An unusual strain, who's going to determine the unexpected cause? I believe those words are not as commonly defined or as utilized. It's almost like if you see it, right? And we talked about what level of abstraction are you going to look at? Is it going to be a phone call involving a death? Is it going to be a dead baby? Or is it going to be a dead baby where maybe there was murder involved with a claw hammer? Who gets to decide what it rises to the level of trauma? And we believe that's more for the medical experts, and the agency can weigh competing expert opinions. I don't believe the Brown court stood for if a worker can prove because of a work event they sustained PTSD, but legally can't. I don't believe the Brown court intended to deny benefits to first responders. We're not asking for special treatment for first responders. We're just asking to be on the same playing field.
Broaden Brown so that the fact finder looks at, you know, how anyone would react to it, rather than how would a 911 operator react to this.
Right, because by considering the occupation, you're now allowing the defendants to bring in the assumption of risk doctrine, which is something workers' compensation doesn't permit.
So one of two things needs to happen. We choose to overrule Brown, which the legislature has left alone, even though they've tinkered with the Work Compact repeatedly, including the case Justice Mansfield just mentioned. Isn't this more of a policy decision? We should defer to the elected branches to see if they want to make the choice to allow people in risky, stressful jobs day to day should get comp for their mental injuries. Who should decide?
Court's decision to make, as the legislature has allowed the court to determine mental injuries and the policy behind legal causation. I just don't believe the court intended for...
Our prior cases that have had both medical and legal causation, you're asking us in a sense to strip the legal causation.
What we're asking for specifically for post-traumatic stress disorder, that there's a sufficient badge of reliability with that diagnosis.
So I think it's a stripping, and the next thing's going to be, you give a mouse a cookie. We do it for PTSD, and like I said, everybody else is going to come around and say the same thing about their diagnosis or whatever it may be. But aren't you, when you say that they haven't done anything to it yet, couldn't we assume it's because maybe with the medical and legal causation requirements that we have in our case law, that is what has satisfied the legislature from leaving it alone?
It's possible, but I don't believe this court has ever decided regarding first responders. I think Brown involved a gas station attendant. What we're talking about is something that this court has not seen, and that's when You have a profession where the community expects them to put their life on the line every day. And whether after they see a traumatic event, hear a traumatic event, and not be able to recover benefits, their only legal remedy, that's what we're talking about here today. It's the next logical extension after Brown. So, thank you, Your Honor.
Versus Scott Emergency Communication is hereby submitted. And we'll have a transition with attorneys, and we'll tee it up for American Home Insurance versus Liberty Mutual Fire Insurance.